Hello, everybody. Welcome back to Conduct Detrimental. We're back with some more Ezekiel Elliott, the case that keeps on giving. We're back in kind of that Deflategate mode, Dan, where we're seeing court filings almost on a daily basis, new issues coming up on a daily basis. This is pretty crazy, isn't it?
I think we're going to have to rename our show Fundamental Fairness. Forget Conduct Detrimental. I think as this case begins to take on this, nastiness, and we're starting to see, gamesmanship between, among the different, parties, the NFL and the NFLPA cannot stand each other. And now we have, for the first time, animosity from the NFL towards Judge, Amos Mazant. So this is taking on a much more emotional feeling than I think Deflategate ever had, and that's shocking to me. I thought Deflategate was the case that had all the drama and all the great angles, and we're about to enter a dimension right now that could last at least in the short term with all these stay issues for the next couple of weeks. And then, of course, we're going to have an appeal to deal with and some jockeying in the lower courts. So this is for sure, between the two cases at this juncture, much more fascinating than Deflategate was. And I can't believe I'm saying that.
Exactly. And you referred to, this being in two separate cases. And really, we're in three courts right now. We're in District Court of Texas. The NFL has already filed its notice of appeal in the Fifth Circuit, in that case on the injunction. And then also the lawsuit in New York. So maybe it makes sense to kind of talk about each of these in a separate bucket, and they all kind of go hand in hand and have some crossover. But let's start with the case that, has seen all of the action to this point just about, and that is in the District Court of Texas. Right now we're waiting here on Thursday afternoon. Dan is currently refreshing the Pacer docket because we are expecting a potential ruling on a fully briefed motion by the NFL to stay the injunction pending appeal, which means that they are asking the court to undo the injunction and essentially have Ezekiel Elliott's suspension begin immediately instead of wait like the ruling before. Dan, I know that you've tweeted about this and we've talked about it, but the NFL really mailed it in here, didn't they?
Oh, yeah. I mean, first of all, the league's objective was to get to the Fifth Circuit as quickly as possible. They had that reply brief and that petition for a stay pending appeal, done bang, bang fashion, and it didn't seem to be one of the better briefs or extensively laid out legal arguments I've seen. It was almost designed to fail. They covered all the bases, but only in my view, the bare minimum to get before the Fifth Circuit as quickly as possible, but without waiving any of their arguments. See, the league can mail it in, but it can't fail to raise arguments. But there was a lack of in-depth, advocacy that I think I would have brought to bear if I was preparing this motion. So it was, by design of the federal rules of appellate procedure, a party seeking a stay has to go through this two-step process. And if you're seeking a stay pending appeal, you have to apply for a stay before the lower court first. And it has to be denied or failed to, or the lower court fails to afford the relief requested, which is, another way of saying the court sits on it forever or just doesn't act on it. But to have a lower court judge stay his own injunction is somewhat incongruous. And there is almost no precedent that I'm aware of for a lower court staying its own injunction that was entered days earlier based upon a threat of irreparable harm to the party that got the injunction. So the league wants to see Elliott suspended as quickly as possible, and the relief and the recourse is going to come solely from the Fifth Circuit. So the league wanted to have this issue presented and preserved for Fifth Circuit review this week, and Judge Mazant kind of messed up those plans by surprisingly issuing a briefing order that would span the course of the full week.
Yeah, this reminds me of another type of motion that you see in federal court, and that's a motion for reconsideration. And essentially, the stay motion and a reconsideration motion are asking the judge to look at what he just put out and completely change his mind on it. And the only time I've ever seen those change is when a party properly identifies a mistake of fact or law that the judge made when coming to his opinion. And here in the NFL's motion, you don't even see them identifying any sort of potential mistake that the judge made. And so, because of that, and, they're clearly just going through the procedural steps that they have to. But I mean, I would give them a 0.00000. I don't even put a 1 on the end of that chance of winning this motion. It's really just a formality moving forward. Do you agree with that?
It's -0. I mean, what makes it -0 in this instance is that the standards governing a stay pending appeal were the exact same standards that applied to the issuance of the preliminary injunction. The judge has already gone through this analysis and determined Elliott and the Players Association had a substantial likelihood of success. Elliott would suffer irreparable harm. The balancing of the harms tips in Elliott's favor, and it would not disserve the public interest to enter an injunction for Elliott. So the judge has essentially made preliminary findings on all 4 of those elements. He's now being asked to readdress those elements. It's almost like a backdoor motion for reconsideration. But the judge isn't going to come out any differently. And the danger to entering a stay pending appeal is that granting it would give the league all the relief that it seeks in the case, which is the ability to impose a 6-game suspension right now. So I think the absence of harm to the NFL and the abundance of harm to Elliott, coupled with basically giving the league all of the relief it's looking for here, would moot the appeal and leave Elliott with a potential Pyrrhic victory at the end of the line. I just don't see Mazant doing it, and I don't see the Fifth Circuit doing it, even if the Fifth Circuit believes that the league has the much better of the cases. You can't get around the absence of irreparable harm to the league, and certainly no one can contest that Ezekiel Elliott will suffer significant irreparable harm from missing 6 games. The federal case law in a number of different professional athlete cases uniformly recognize that principle, and replacing the missed games is an impossibility. A game check doesn't equate to missed time, and in an athlete's short playing career, the opportunity to achieve honors and awards and keep pace with your peers and make the Pro Bowl, the All Pro, none of that can be recaptured once those games are taken away.
Yeah. Kind of taking a step back from there, we'll get to some of those arguments in a minute, but I think there's some really interesting issues that are brought up by this NFL's motion, even though it's destined to be a loser, and one of them is the timing. As you noted, they tried to sneak it in and have the judge rule really fast, and he, in turn surprised them with essentially stretching it out a week by issuing a briefing schedule and requiring the NFLPA to respond, and then the NFL has a chance to file their reply brief, and they filed their reply brief yesterday, almost immediately after the NFLPA filed theirs, which was 2 days before their deadline. And one of the interesting parts of the brief, because it was actually just kind of a regurgitation other than this piece, was that they essentially gave the judge an ultimatum. They said, if you don't rule today, we're going to file our emergency motion in the Fifth Circuit, so they didn't say you better do so, but that's essentially what they were implying, which is a pretty bold move. Obviously, they didn't have much to lose. Mazant, and we'll talk about the injunction order in a minute, because we didn't get a chance to talk about it in our last podcast because it came out immediately after that. But, Mazant obviously ruled heavily in the NFLPA's favor, and so now the NFL's pushing back. Dan, would you ever give a federal judge an ultimatum on a timing issue?
Only if I was never going to appear in that circuit or jurisdiction ever again. And this is not Paul Clement from Washington, D.C. making that ultimatum, knowing that he'll never be in the Eastern District of Texas again. These are lawyers from Aiken Gump, which are presumably frequent travelers in the Texas federal courts. And no client is worth making that kind of ultimatum. I don't care if it's the National Football League. Cases come and go, but as a practitioner, you've got to be in that courtroom. And the lawyers in this case will presumably appear in the Eastern District of Texas again and have another case before Judge Mazant. And you don't want to leave a judge. You don't want to be antagonistic towards the judge. I know the NFL used words like respectfully, but it was a veiled threat that if he doesn't rule, same day or before the end of the day Thursday, they're going to take action. You don't ever threaten a federal court. First of all, it's a terrible optic for practicing before any of the federal district courts. But the Fifth Circuit is not unaware of what's going on in the lower court, and will have the benefit of the briefing. And you might have ticked off a Fifth Circuit judge as well. I think the NFL needed to take the high road here. This threat wasn't necessary because even though the league quickly filed its reply brief, Mazant wasn't going to stretch this out to next week. He was going to rule, within a day or two of whenever that reply brief was filed. So the NFL wasn't really in jeopardy of losing all that much had they not made the threat. Yeah, maybe Elliott plays this week against if they're playing the Broncos. If the league seems hell-bent on engineering a suspension in time for this Sunday, it's just not going to happen. The Fifth Circuit is not going to accept a petition filed on late Thursday night or Friday, impose a briefing schedule, require the parties to complete their briefing before Sunday. It's just not going to happen. I mean, I could be proven wrong here, but I think Elliott's eligibility for this week is now, without a doubt, not in question. He plays this week. So I think the NFL should have been looking, or should have looked at the sort of the bigger picture here, which is they're going to have an opportunity to argue their motion for stay before the Fifth Circuit, whether it's Friday, Monday, or Tuesday. They will get their day in court, maybe not an oral argument or a hearing, but they will get a ruling from the Fifth Circuit before the end of next week. So there was no need to be so heavy-handed in the approach towards Judge Mazant. This week wasn't all or nothing. They will have their opportunity to get their pound of flesh, whether it's in week 3 or week 4, but they'll have their chance to argue for a stay. They're not going to get it. The irreparable harm deficiency doesn't go away if you simply go from the district court to the Fifth Circuit. The same problem looms for the NFL, and that they cannot prevail on that element, at least not in my opinion.
Yeah, when I saw that, I really asked myself, like, what is the NFL thinking here? And to me, I think they're trying to be able to make the argument to the Fifth Circuit that they're doing everything in their power when they're filing this emergency motion in the coming days, that they did everything to move this thing along as fast as possible because it's such an important issue, and the Fifth Circuit needs to act swiftly and quickly on this. But I think you nailed it on the head when you said that the Fifth Circuit's likely are paying attention to this case, or the judges that are assigned will eventually begin paying attention to this case, and they're going to see that. And I think it really has the chance to rub those judges the wrong way, and really could backfire on the NFL and not make any friends in the Fifth Circuit, which is, the last thing that they want to do at this point. We saw in many of these cases how these cases go, because they're good lawyers on both sides. It comes down to the judge. We saw Judge Berman, side with Brady, and then we saw them appeal that case and go completely the opposite way. There's a chance that could happen here. So every little bit of favor that the NFL can muster and not give away is going to be important. So that this could turn out to be a misstep. And so moving forward, the next question to me is, and as I mentioned, we're refreshing Pacers, so if this breaks in the middle, we'll talk about it. It hasn't currently. But will Mazant abide with their ultimatum? And I tend to think, it's now 1:30 on Thursday. I tend to think that maybe he's just going to take his time anyway. He's not going to. He's not going to do it. That'll actually muck up the NFL's emergency stay motion in the Fifth Circuit anyway. If they file it before they can rule, it'll give them more problems. One of our colleagues was tracking Mazant's caseload and noticed that he was in trial today. So currently, obviously, he's got plenty of other cases going on as well.
That's our embedded correspondent, Frank Cawley.
Yeah, thanks, Frank, for all your digging on this case. We appreciate it. And so there's a lot of issues, or a lot of reasons why I think we might not see this till tomorrow or even later. I mean, he's scheduled to get the final brief tomorrow, and then was going to work on the opinion after that. So who knows? Who knows if he'll change his schedule around and bend over backwards to the NFL to rule today. I would imagine if it would happen, it would probably be pretty late. But I don't know. I just don't see it. What do you think, Dan?
Well, my theory is that he's going to wait until after the close of business on Thursday, which we're recording today. I think he's got to not overplay his hand with too much delay. I mean, this is not going to go into next week. If he was going to be in a position to rule by Friday night under the original schedule, I mean, he really should try to rule by the end of the day today. But from his perspective, he's pissed, right? He's certainly not happy about the sort of the ultimatum that the NFL made in the last page of the reply brief. So one way that he could sort of like stick it to the NFL, not that judges want to stick it to parties, but there's one subtle passive aggressive thing that he can do, which is to deny the NFL the ability to get into the Fifth Circuit on Thursday. And if he had issued the ruling earlier in the day Thursday, it's going to be bang, bang. 1 hour later, the NFL will file in the Fifth Circuit and potentially get the kind of briefing order that could maybe jeopardize Elliott's eligibility for the Sunday game against the Broncos, because the court could demand a brief from the union by noon on Friday, a reply brief from the NFL 5 p.m. on Friday, and maybe issue a ruling by late Friday night. So by delaying the ruling until after the close of business, Mazant could potentially jeopardize that slim possibility that the NFL holds out some hope for of having a lightning fast briefing schedule before the Fifth Circuit, all of which would take place, late Thursday and on Friday. So I think my money is going to be on Mazant ruling today, but waiting until a little bit late into the evening.
Hey, Conduct Detrimental fans, we have some big news to report. We have our first actual sponsor for the podcast. And it's on a topic that's near and dear to our hearts, fantasy football. So if you love fantasy football, then you need to try our new favorite app, Draft. It's weekly fantasy football, but not like the other guys. On Draft, you draft real live snake drafts with other people, just like in your season-long league. Here's how it works. It's a draft that lasts for just 1 week, and there's no management. Just set it and forget it. Once you're done drafting, that's it. No trades, no waiver wire. Draft even takes care of the last-minute injuries for you. Drafts start every couple minutes, so you can join one right now. And the best part, you can play for cold, hard cash. Drafts start at just $1, so there's a draft for everyone. No salary caps, playing a real live snake draft, just like you play with your friends in a season-long league. Come join us on Draft today. Download the app at any time. Just search Draft in your app store and join a game in minutes. Or play right from your computer at playdraft.com, whichever way you want. For a limited time only, all new players get a free entry into Draft when you make your first deposit. But you have to use our promo code, which is SportsLaw. That's right, kind of detrimental fans. Play in a real money game for free by just using the promo code SportsLaw on your first deposit of the draft. Just search Draft in the App Store or go to playdraft.com and come play with our free promo code SportsLaw, and we're back at it. Speaking of Dan's predictions, you've been on a hot streak recently, I'll say, and you nailed basically what was Judge Mazant's injunction order, which issued last week. That was last week, right? Yeah. We last recorded last week. I think the day that it came out, we recorded earlier in the day. We knew it was going to come out that day. You predicted that Elliott would win. I was a little bit more on the fence. But I think we'd be remiss if we didn't at least talk about that a little bit, because it is a huge order in the case, not only because it granted the injunction, but he discussed the likelihood of success on the merits, which is the future of this case, really, and had some strong reasons why to believe that Elliott will ultimately prevail, at least at the district court level. Dan, what was we don't need to get too much in the nitty-gritty of that because people probably know all about it, but, what were your kind of general thoughts on that order? For me, it was extremely heavy-handed against the NFL, towards the NFLPA. Some very strong language for arbitrator Harold Henderson. What were your general takeaways? The theme of the brief was the fundamental fairness issue, which, my prediction was, not just based on thinking that, maybe, they have a 50-50 shot, so I'll be an outlier here. I saw the same deficiencies that occurred in the Brady case,
But here we're much more pernicious because you're dealing with the accuser in a dispute that's almost like a criminal domestic violence accusation. So the need to have to be able to confront and cross-examine your accuser and have access to the next best thing, which are the notes, I think we're far more acute in the Elliott case than they were in Brady, which centered on, besides the notice issue, the need to have testimony from Jeffrey Pash, who played a far less critical role in that case than Tiffany Thompson played in this controversy. So I kind of spotted that early on, and I think our experience in covering Deflategate and writing about it, and you and I, spent so many hours 2 years ago, probably hundreds of hours immersed in the minutia of the case, that this fundamental fairness issue seemed to become revived again. But in my view, it was much stronger. So, this case also had the added intrigue of the league's attempt to conceal Kia Roberts, the critical, lead interviewer for, who spoke with Tiffany Thompson a number of times. And I think the combination of the deprivation of a fundamental witness with the league's attempts to hide Ms. Roberts' opinions from the Players Association made this a slam dunk, at least case from my perspective. But the weakness or the potential vulnerability going forward is in my view, not the merits of the arguments, but the timeliness, the jurisdictional issue, standing, ripeness, exhaustion. To the extent there's any vulnerability in Judge Mazant's opinion, it's going to focus on the jurisdictional grounds of whether he properly had jurisdiction to weigh in on the dispute before a final arbitration award. That's where the rubber meets the road. And if the NFL is going to have any high likelihood of succeeding on appeal, I think that's where the rubber meets the road. That's really the key issue. I think fundamental fairness is a slam dunk on the merits. I don't care about Deflategate. You can easily distinguish the scenario and the need for the testimony in Deflategate, which was far less important, from the need to have the accuser here. So the NFL's best hope for success on appeal and ultimately on the merits is going to lie in the exhaustion issue, the ripeness issue, and the standing issue, which are related issues that center on whether this case was properly brought at the time it was brought.
Yeah, and a couple follow-up points there. I mean, I think Mazant, took the time to focus and differentiate this case from Deflategate, because really, the NFL, as we've noted throughout this process, has heavily relied on Deflategate and cites it frequently. I think 8 or 9 times during one brief. You don't see a brief going by without it. And so Mazant had to get through those factual issues. And a few times I wrote down a couple quotes about it here. He called, he recognized that in these cases that an arbitrator, and this is a point that was made by the Second Circuit in Deflategate, the arbitrator has the ability to make evidentiary decisions, right? To exclude witnesses, to under the CBA, to talk about what documents are discoverable and not. And he said that was a normal case. And then he said everything about this case was anything but ordinary, and that Harold Henderson conducted serious misconduct by the way he acted in this case. And so just by those phrases, he's taking this out of the Deflategate realm and pushing it towards the fundamental fairness realm, which the Deflategate courts essentially punted on too.
Hey Dan, do you think Judge Mazant is hinting at an evident partiality finding? I mean, he did conclude, at least, or preliminarily find that that Harold Henderson breached his CBA obligations. I mean, is he going to go there? I mean, in light of the Adrian Peterson ruling and the court's determination that there was an NFLPA waiver of that argument by virtue of what they collectively bargained, I have the sense that there's potential evidence here to find to go down that route.
I think it's possible too. I don't think he has to. I'll put it that way. I think he can just rely on that. Henderson messed up and didn't do his job well and shouldn't have taken these extreme steps and therefore conducted misconduct. It doesn't have to go to partiality, but I think he certainly could. So I think the potential is there.
I thought one of Berman's biggest mistakes in Deflategate was not fleshing out his ruling on evident partiality, and he basically gave the Second Circuit an opportunity to weigh in and on first impression on that issue and completely dispense with it. I thought had Berman built a better foundation for a finding of evident partiality, it might have, not that it would have changed the result, but he never got the issue back on remand. So unless you address it in the lower court, the appellate court may take that issue away from you. So maybe if Mazant is going to study the Deflategate lower court ruling, he may not want to leave any potential issues on the cutting room floor.
Yeah, and it was surprising to me that issue just got smacked away in Deflategate because I thought it's a pretty strong argument, especially in the facts of that case. Here where they at least put a different arbitrator up, even though the arbitrator, is a former NFL employee, is clearly at the mercy of the NFL, it seems. At least they put someone else up. I was sort of surprised, honestly, when Goodell didn't name himself arbitrator in this case. It ultimately didn't make a difference, and that was probably his point of not doing it. But at the same time, it was still surprising to me. But yeah, I think that's definitely an interesting storyline to follow moving forward. Because again, it's one of the NFL's strong points from a precedent perspective at this point. So yeah, that's kind of how, to me, they were kind of moving away from Deflategate. And then to get to your other point 10 minutes ago, talking about the exhaustion, again, we're talking an exception here. Judge Mazant calls this an exception. Usually the rule is you have to wait until you've exhausted all of your remedies at the CBA prescribed remedies, which include the arbitration. You had to wait for Harold Henderson to rule before you file the case, and then it's first to file, and then that's why the NFL was waiting. That's why the NFLPA arguably jumped the gun a little bit. But Mazant says that there's some exceptions to this rule, right? And one of them that he really focuses on is that the NFL's actions amounted to a repudiation of the remedial procedures in the CBA. So he's saying things like the NFL's missteps with Kia Roberts, Henderson's missteps with denying the interview notes, the accuser testimony in Goodell, were actual repudiations of the process of the CBA. And that's really interesting to me because let's say this opinion holds up, okay? Moving forward, what does this process look like, right? So for every domestic violence case that gets appealed, now the arbitrator basically has to compel Roger Goodell to give testimony, compel the accuser to give testimony, which is really interesting just from what we've seen in domestic violence cases in criminal courts, where oftentimes that will, because, and totally understandably so, victims frequently don't want to testify for a number of reasons that we don't need to get into right now, and the cases will be dismissed. And so will the NFL's domestic violence powers only be there if they can convince the accuser to testify during the arbitration hearing? And that's, to a certain extent, that's what this order is saying.
Yeah, well, Dan, I think it depends in large part on the during the investigation. If you have a recalcitrant witness to begin with who wants no part of the NFL investigation, well, certainly the NFL cannot expect her to participate in an arbitration proceeding. But we have a situation here where the accuser voluntarily and gladly work closely with league investigators, and while the witness can't be compelled by the NFL, they didn't even ask and made her unavailable without us knowing, without the union knowing whether she had any interest. Obviously, she could fight it. She could cooperate with the investigators from the league, and then fight any attempts to participate in the arbitration proceeding. But then that would provide Elliott and the union with a strong argument that whatever statement she gave to the league should be disregarded. So I think, I
mean, I think it's a great point that there are cases where there's enough other strong evidence in criminal court to get a conviction without the accuser testifying, or here, which is, as we know, a lower standard, to proceed without that. But, I think in the vast majority of cases, you're probably going to need her. And that sets up a whole different dynamic. And I don't know that the NFL, wants to go down that road. They've never been one to compel the accuser to participate. They have, this is pre this whole domestic violence department, essentially, in the NFL head offices, where they had Janae Rice come in and interview with Roger Goodell, which, as we all know, many of us knew then, and we all know now, that was a huge no-no on Goodell's part, and he's since apologized for that. But I guess the point being that there's some potential long-lasting impacts of this type of decision on how the NFL is going to be able to enforce their personal conduct policy, and particularly the domestic violence policy, moving forward.
Yeah. But we're going to be probably a while away from the outcome, the merits of the appeal. I think the stay issue is really more important because it will signal where the Fifth Circuit ultimately will come out on this. Okay, and we haven't even talked about the New York lawsuit, because the Fifth Circuit may find, I think the NFL will, stress some of the jurisdictional defects of the Texas filing. So I think the New York lawsuit that basically the league bought an index number 2 weeks ago, and that case is sitting in a fairly inactive status. But I think the league's hope is that the Fifth Circuit will, the Fifth Circuit will reverse whatever Judge Mazzan's final holding is on jurisdictional grounds, and not necessarily address the vacator or the confirmation issue. And this New York lawsuit could reemerge as the forum choice, depending upon how the Fifth Circuit ultimately rules. But I don't think the Fifth Circuit is going to take any drastic action on a stay issue. This will have to be briefed and ultimately resolved by the Fifth Circuit on the final merits. So I think the reason the New York lawsuit has had no activity is that the league anticipates that this case ultimately may find its way to the Southern District of New York, where, in its view, it properly should be litigated.
Yeah. Are you surprised that the PA hasn't taken any action in New York and tried to push the court to essentially dismiss the case because of Mazzan's ruling saying that he has jurisdiction?
Well, I think on the basis of the first file rule, the union has a very strong argument that the Texas action certainly came first chronologically, and you could take the subsequent award, which came a day or two later, amend the complaint in Texas and have it relate back to the first. But I think the union may be wary of asking for something and getting one of those rulings that could be contrary to its interests. So I don't know if there's any benefit for the union to try to press the venue issue in New York when Judge Mazzan is already conducting extensive proceedings on a TRO, issued a ruling. I mean, the greater goal of the NFL Players Association is to keep pressing the matter in Texas. They have an injunction. Pursue this, to brief the appeal. The longer that this case goes on in Texas, the less likely it is that New York will end up being a viable forum. The only pathway for the Southern District of New York to exist as an alternative forum is if the Fifth Circuit reverses Mazzan on jurisdictional grounds and finds that the entire lawsuit was improperly brought because it was commenced prior to the issuance of the award. If the Fifth Circuit months from now rules on that basis, the Southern District becomes the forum in which to litigate the case. And I'm not convinced that the NFL wouldn't want parallel proceedings right now. So that those may activate at some time in the future soon, and not necessarily following the plenary appeal before the Fifth Circuit. So I'm still kind of waiting for the next shoe to drop in the Southern District. It could come soon, but that's where the league still believes this case should be litigated.
Yeah, wouldn't that be something if it on this appeal, the appellate court says, hey, this isn't the wrong forum, and we kind of do a complete start over in the Southern District of New York. That would be kind of wild. I think at this point that's probably unlikely. I disagree that with you that the exhaustion argument is necessarily weaker than the injunction argument, but we'll see. I think they're pretty strong on both fronts. I'm more, I think if the NFL ever wants to win this case, I think it's going to come down to them going, or actually litigating the merits of the case in the district court, which they're probably going to lose, but then appealing and then winning at the Fifth Circuit. I think that's the most likely outcome where the NFL comes out on top here, is winning in the Fifth Circuit after the merits case. And that'll be essentially the second appeal in the Fifth Circuit.
Yeah. Dan, I don't think we even have to wait that long. We're going to know how the Fifth Circuit's going to rule on the appeal by the end of next week, because the grant or denial of the stay motion is basically the Fifth Circuit's preview into the merits of the case. And if the Fifth Circuit issues a stay pending appeal, they're telegraphing that the NFL is going to win the appeal. Okay, I mean the issues will be somewhat crystallized, maybe not fully briefed to the same depth as it would on a full appeal, but I would use the grant or denial of the stay, of the requested stay, as a predictor, an almost 100% predictor of what the final Fifth Circuit decision would look like potentially months from now. I mean, if they're going to grant the stay, case is over, league is going to win on appeal. And conversely, if the court denies a stay, I don't think that necessarily portends NFLPA victory on appeal, because the court.
Yeah, I think if they go with I don't mean to interrupt you, but I think if they go with strong words on the irreparable harm front.
Irreparable harm just relates to the preliminary injunction. It doesn't relate to the merits of the arbitration. So I think the predictive result would be the issuance of a stay. I think it would be pretty much case over. I mean, you're telling the parties that we believe the league has a substantial likelihood of success. What would change between that order and then on the full briefing of the appeal? So I think the Fifth Circuit's opinion, or Fifth Circuit's order in this case, which we could see coming down, as soon as potentially late Friday night, or at some point next week, it could be the most telling action in the case that could really provide clarity, for the parties for months going forward.
I think the scenario where which is probably the most likely one, they deny the stay, and we get kind of a wishy-washy discussion of likelihood of success in the merits. They say that both sides have good arguments. That really leaves us in the dark on where they're going to rule, and it kind of keeps the tension up moving forward. And I don't know. I don't know if they would do that or not, but I also, if they're going to rule quickly and they see an easy out by saying there's irreparable harm here, no question, we are going to keep this stay going and let the process actually play out in the lower court. I mean, I think it's at least possible we get that, and we are suspenseful moving forward.
Yeah, one other thing that I think we need to flag here is there's a strong possibility, and I've predicted that the NFL is going to lose this issue before Mazant, before the Fifth Circuit, before the Morris Supreme Court. I mean, it doesn't matter where this is litigated, but once the denial is issued, be it this week or next week, the league also has to be concerned about this appeal bleeding over into the 2018 NFL season. I mean, most appeals take, in the neighborhood of between 9 and 11 months, and depending upon how busy a court's docket is, there is a possibility that this appeal could, who knows what Judge Mazant's schedule will be on the final hearing, or when we'll get a final judgment on a motion to vacate the arbitration award. But there's a possibility that there would not be closure by the beginning of next NFL season. And what we're going to likely see here is if the court grants the stay, it will be automatically an expedited appeal, just going to a shortened, truncated briefing schedule, and we're going to have a resolution on the merits by the spring. But if the stay is denied, I think the league would want the protection of not having this appeal pending next year during the season. And I think the Players Association and the league would probably do what they did in Deflategate, which is jointly request an expedition of the appeal to ensure that there's a decision on at the Fifth Circuit, certainly by before the beginning of the 2018 NFL season. But we're not at that stage yet, because this is not an appeal of the decision on the merits. This is simply an appeal of the preliminary injunction ruling. But there could come a point in time where the league and the union actually agree on one thing, which is to have an expedited appeal.
Yeah, I mean, I think there's certainly a possibility of this bleeding over into next season. I'm not confident in it, and although Mazant's kind of done most of the legwork at this point, but I think there's still going to be a full briefing schedule. They still have to do the motion to dismiss. I mean, in normal court terms, all of this could take up to 6-8 months just at the district court level before the appeal. I think he'll move faster than that because a lot of this is already briefed out. The parties are going to agree to shorter deadlines to try to move it, likely.
And no discovery. There are no depositions or
even
requests
so,
for
right.
The record is the record below. It's not going to change.
Right. But even so, I mean, if there was discovery, obviously that kicks it out a whole another year plus. But anyway, it's going to move. It's going to move relatively fast to the district court, and then it'll come down to how quickly the appeals courts want to take it and move it along, get an oral argument in, and then write an opinion. Still pretty tight on the deadlines before 2018, even if everything kind of runs smoothly. You're still looking at 10 to 12 months for those two processes to take place, even quickly. And, it'll certainly, I think there's at least a chance that it could be an open question in preseason next year, and we're going to be talking about this late summer. When is this thing's going to be resolved? When are we going to hear from the Fifth Circuit? So it'll be fun. I think that's probably a good point to cut it off, Dan, for today. I'm sure we'll be back talking more Ezekiel Elliott, unless you have any parting thoughts.
Well, let's do our predictions. I mean, the easiest prediction. This is you didn't make the money prediction last week, but now you have a layup.
Yeah.
All right. Let's call the motion before Mazant. I think we both agree that it will be denied. In fact, He's probably already written the order. How do you see the Fifth Circuit ruling, Dan?
I see that also being the motion for emergency stay denied as well. You?
Yeah, I'm going to copy you on this, and I think the irreparable harm issue precludes emergency stay relief here. There's no question, unless the only equivocation I make on that, and I'm definitely predicting the Fifth Circuit denies the motion. But if the Fifth Circuit employs a sliding scale approach to the elements on a motion for a stay, if you have a strong showing of a likelihood of success on the merits, well, then that would allow a lesser showing of irreparable harm. But here I don't think the league has any irreparable harm, and all the harm is in Elliott's camp. So even under a sliding scale approach, I don't think the NFL has enough to get it over the hump, and we're going to be back before Judge Mazant in another 2 weeks with presumably a briefing schedule on the motion to vacate the arbitration award. And I think he'll keep the case, but it's going to be a flurry of activity today, tomorrow, and next week is going to be a big week because the Fifth Circuit's ruling really will dictate the future of this litigation.
I agree. It's not slowing down anytime soon, at least in the next 10 days or so, depending on how quickly the Fifth Circuit moves. But we'll be at it, and we'll be sure to have you all covered. Thanks for tuning in. Please give us a rating on iTunes, only if it's a good rating, and say hello to us on Twitter. Dan Wallach's handle is @WallachLegal. I am @WorleySportsLaw. Thanks, everybody.
Wallach case.